Good morning, sir. With your kind permission, can we start?
Yes, yes.
Good morning to everyone present here. I, Avneet Kaur, delegate of Sambhav Initiative and moderator of this event. On behalf of organizing committee, I extend a warm welcome to our esteemed dignitary, Sri Avadhoot Sumant, sir, and to all the participants in this seventh day of 15 days online national capacity building program on land, real estate, and property laws, jointly organized by Sambhav Initiative, which is working towards alternative dispute resolution, free legal aid, mental health, and creating legal literacy. Organized this program under the direction and guidance of Patron in Chief of Sambhav Initiative, Honorable Mr. Justice C.K. Thakkar, sir, former Judge of Supreme Court of India, and Patron of Sambhav Initiative, Honorable Mr. Justice M.R. Shah, sir, former Judge of Supreme Court of India, and Pro Bono India, which is working towards legal literacy and legal aid, where today's session is all about procedure and principle for transfer of various property through various ways. Before we start the session, please adhere to some webinar etiquettes. I request all the attendees to keep their microphones muted during the session. If you have any questions, please use the chat box or you can ask your questions or raise your hand. It is my privilege to introduce our esteemed dignitary, Sri Avadhoot Sumant, sir. Sir is an accomplished legal professional, holds a Bachelor of Arts degree from MS University of Baroda. Sir further obtained his LLB General between 1987 and 1989 and subsequently completed his LLB Special in 1989 to 1990 from the same university. Additionally, Sir holds a postgraduate diploma in intellectual property rights law from the National Law School of India University, Bangalore. Sir has been practicing as an advocate since 1990 across various districts and sessions court in Gujarat and other jurisdictions in India. Sir is the founding partner of the Satyavidhi and Company, advocates and consultants, and also serves as a partner in the associate firm, the Satyanidhi and Company. With over 3 decades of extensive experience, Sir has developed expertise in corporate laws, civil and quasi criminal litigation, arbitration, RTR proceedings, and matters before the National Consumer Forum. Sir has a distinguished practice in the field of intellectual property rights, handling complex issues related to foreign patents, trademarks, and copyright litigation across India. Sir has actively participated in domestic inquiries and large scale arbitration proceedings involving significant contracts and industrial projects. As a trusted legal advisor and retainer for numerous multinational, national, and medium to large scale industries for over 21 years, Sir brings a strategic and solution oriented approach to legal consultancy. Sir has also been engaged in legal education and professional training, contributing as a speaker and trainer to institutions such as the Institute of Chartered Accountants of India, Western India Regional Council, National Academy of Indian Railway, MS University, Faculty of Law, Faculty of Management, Department of Architecture, Police Training School, IRMA, IIMM, and various other professional bodies. Notably, Sir was appointed as a district judge but chose to continue his career in active legal practice, demonstrating his deep commitment to the legal profession. We are deeply honored to have you with us today, sir. Over to you, sir.
Namaste to one and all. I always believe that, any learning and education, formal, informal, including the session today, I always start with the prayers. So I say my prayers. Sarvetra Sukhina Santu, Sarve Santu Niramaya, Sarve Bhadrani Pashyantu, Ma Kashchit Dukhabhag Bhavet. Everybody in the world should become happy. That is the universal and larger than the life prayers with which we start our session today. Friends, let us draw some small primary rules in my session. I know that generally the sessions are being devised in a manner which are required to be dealt with in a manner as it is decided. But I would like to make it very simple and state that always these kind of training sessions are meant not for the type of processes which happens in the classroom in the colleges where one person speaks and you people listen. I wish that let this be interactive in the course of my session with you. If any participant desires or wishes to raise the hand physically, you can do it on a screen. Would be more than happy to interact even in the course of the session. I believe that should be a thought sharing process instead of lecturing, which of course I believe it's one of the important tool. But today, let's keep that rule alive between us. I speak, you listen. Sometimes you speak, I listen and try to answer you. So, with this small rule set, let us start. Basically, the subject as it is shared with me is that procedure and principle for transfer of various properties through various ways. So I believe the topic has an essential element of existence of the concept of property and existence of the process to transfer. So generally, when we start discussing that what are the types of the properties, we generally are made known to know the movable property, which we all know well, the chattels or the goods as it is controlled by the Sale of Goods Act, then immovable property, and of course we are all aware about the another classification by virtue of the physical attribution, namely tangible and intangible. And we are all aware that so far as the intangible is concerned, it includes all the intellectual property rights which are commercially known, so far as trademarks, copyrights, designs, patents. But now, in view of global economy and the change in it, and after unicitral United Nations has adopted the GI tags, as we have heard the case 2 days before, Tirupati Laddu, Kolhapuri Chappal, Basmati rice. These are the intellectual property rights, including semiconductor chips, including the plant and varieties. These are the newer areas of intellectual or intangible nature properties. But now I believe that ultimately the concept of property changes with the society and the values or structures in the society. If I would make a statement that we are here working on this really a great knowledge sharing platform created by Sambhav, and if I say that I can get an injunction qua the goodwill of the name Hiranshi, I know you will be shocked to know, but there are not less than in India, though of late there is a development. Technically, the property is existing in the name and identity of either Amitabh Bachchan or Hiranshi. Why? Because the person is capable to create a goodwill. It has a kind of a shade of the trademark and the case laws. 2 days before, if you know, Jaggi Vasudev Sadhguru, whom we all know well, he has moved the Delhi High Court, and this is a type of the property. If you open the traditional law books, either Transfer of Property Act or Intellectual Property Rights Act or otherwise the Sale of Goods Act or any other law which is concerning the traditional concept of property, the time has changed. With full respect, Dr. Devi Prasad Shetty, then Vishnu Manchu, or as I have quoted, down the line or maybe today, Hiranshi World can have the persona rights, and they are being protected in series of cases by Delhi High Court. So I'm just trying to expand, I'm just trying to sensitize that the concept of property as we understand is not always physical. Even the virtual ingredients of the property, Dr. Devi Prasad Shetty and Narayan Dudayalaya moved the matter, and the court granted the John Doe order. I hope everybody is aware. Just giving a small reference, John Doe is the concept which is originating in the kings or the King Edward III, who passed an order that whoever he or she is violating the order of the king, he be arrested. That principle was adopted in American courts, and either the person is known or unknown, if he is trying to encroach upon the value or the goodwill of the person, then the injunctions are granted. These are the examples. So I'm just trying to sensitize you that please come out of the concept of knowing property only as a traditional property. Now there are the avenues are opening, and you will be surprised to believe the trademark. Once we say what we will remember either Jagdish or Ramdev Masala or a Sony or a Cadbury or a Marlboro. you'll be surprised to believe there is a proposition that even the smell can also be considered as a trademark. An attempt has been made in US, where, as we are all aware, that the tires are being sold. The moment you go in a shop of the purchase of a tire, if the sale of the tire is accompanied with some smell, even smell is attempted to be a part of the trademark. So smell is invisible, it is a matter to be felt by your sensory organs, though Evidence Act does recognize the sense of the smell as a fact, as perceived by one of the sensory organ. Putting it in Gujarati, shabda sparsha rupa rasagandha. So when the gandha is there, the smell is also propounded to be registered as trademark. You can just visualize the concept of a trademark is about to be expanded, and the court may accept in the down the line in the course of adjudication. So I'm just trying to sensitize your understanding that when I say word property, don't attribute yourself only to the physical or otherwise the material form of the property. The form which does not exist, which is virtual, also can be considered to be property. These are the few latest examples to propound the principle and the policy that the concept of property is undergoing and has undergone a huge change, and that change is now being recognized by law. The examples I gave you, the smell in a trademark, the persona or the personality rights which are protected, either Sadhguru Jaggi Vasudev or Vishnu Manchu, the Tamil actor, and you all will be surprised to believe the High Court of Delhi, in a matter of Jaggi Vasudev and Vishnu Manchu both, directed to Union Ministry of Electronics and Information Technology that all those people who are using the name of Jaggi Vasudev, those Google and otherwise YouTube channels, they be directed to remove the names. So just visualize an individual name having put in the efforts and labor can create the property in the name and the title. Quoting a philosophy, either it is Avadhoot or Hiranshi, that name is not belonging to me, it was gifted to me. As we are all aware, apna masi athwa to phoi hai, either our maternal aunt or somebody has given this name, but because of your deeds, because of your actions, because of your dedications and commitment for the community, when you act, you are able to create the propertyness. I repeat, a propertyness even in your name. So the name may not be always a trademark, it can travel beyond, and that is how the concept of the property is undergoing very serious change, which is in the nature of expanding, or which is in the nature of increasing the propertyness. And therefore, please friends, remember that traditional laws applicable to the existence or transfer of property, as the topic requires me to maintain the boundary line as to what are the procedures and principles for transfer of various properties through various ways. So when we deal with the modes of the transfer, first you must be all aware that the nature of property is therefore required to be understood. And just recapping, it is movable, immovable, tangible, intangible, intellectual, and now, as I have said, it is a property can be constituted even in the name of the person, provided that person is able to create the goodwill in his life through activities. Quoting a small experience, when I was in a school, one of my teacher had shown the photograph of Maharana Pratap and asked me that, Mr. Sumant, what is the name of your grandfather? I said so and so. His grandfather? I said so and so. His grandfather? I do not know. Then he asked whether Maharana Pratap is your grandfather. I said no. So when you do something in your life and live this wonderful life, you can have, if Maharana Pratap would have been living, then he would have had the similar kind of a propertiness in his name. This is what ultimately the nature of property is undergoing a change, and the law, though not provided for, last on the list, the data also has now become the property, as we all know well. The data which you have shared with Sambhav, with full reverence to reality, it has a property value. So integration of the ordinary information, which includes the name of the person, the age of the person, the area of education, and such data can be, therefore, we are all aware that day in and day out we receive SMSs or otherwise WhatsApp from various finance companies or the banks that we would like to offer a loan. Who has given them the data? the data which you have given it to either in restaurant or otherwise in theater, that data is being shared, which of course is now being controlled by the Data Protection Act. But this is what I'm trying to tell: the compilation of information, the collection of the deeds or actions of the person can create the property completely intangible and with full reverence to the statutory law process, not recognized in any law. Before few months back, till Data Protection Act came into force, before the bomb, the Delhi High Court ruled in favor of Vishnu Manchur, Dr. Devi Dayal Shetty, or Sadhguru Jaggi Vasudev. The concept of the property in the name of the person, persona, facet of the persona. So if I am selling some, a Google Dhoop, I am putting a name of Jaggi Vasudev. Restriction injunction is restrained. The injunction has restrained me from using the name of Jaggi Vasudev. So there are concepts of property now in the modern day world economy, especially in our nation, where startups have now started working very effectively and expansively. Please believe me, you should be very conscious when you want to create the property. Try to gather the protection in as much as possible in the available area of the law. Concluding my discussion on the nature and concept of property, last but not the least, people also call that to be a confidentiality or non-disclosure agreement which occurs between employees and the company. It is advisable that as on today, unfortunately in our nation, namely Bharat and not India, there is no specific law, but contract act does provide that if there is a contract of confidentiality, the information which is provided for in the confidentiality agreement can therefore be protected. One tip for the people who would like to deal with the area of operation or remedial protection: whenever you want to protect any specific property which you treat that as a confidential, it may be customer data, it may be the purchasing pattern, it may be the pattern of the particular class of the society in a particular area of the state or the nation. Like in Gujarat, if you think of Diwali, people will purchase more farsan. That data and collection of data, if you have given it to your marketing manager, then ensure that property is identifiable. There are hundreds of very good judgments passed by Bombay High Court which has ruled that whenever there is a confidentiality attributed by the owner of the property into individual property in non disclosure agreement, confidentiality agreement, these are the types of intangible property. Ill luck is that the nature of the property is not still codified in any law, but still the contract provides the protection. So coming to the conclusion of my primary introduction, the properties are varied. Some of them are already recognized in law, some of them are not recognized in law. So referring to the General Clauses Act, section 3 subsection 26, it defines immovable property, and section 3 subsection 36 defines movable property. But at the same time, I must also at this point of time refer the statutory definition given in the Transfer of Property Act, because if you read a Transfer of Property Act, the title, we feel that it is a law relating to the immovable property, but no, that is not the case. Therefore, one statutory definition: immovable property as defined in General Clauses Act, it very specifically defines in section 3 subsection 26. You allow me to refer the law, because law is the only science which speaks through language. So if you look at section 3 subsection 26, immovable property is defined in three different legislation, namely General Clauses Act, Registration Act, and the Transfer of Property Act. The first two are not of much assistance, for they merely say that immobile property includes things attached to earth or permanently fastened to anything attached to earth. They give no guidance to what is meant by attached to or permanently fastened. The third enactment, namely Section 3, describes what is meant by attached to earth. So that is where it is being provided in the Transfer of Property Act. So that is why the importance of the definition of the Transfer of Property Act plays a pivotal role. It says attached to earth means rooted in the earth as in the case of a trees and shrubs, embedded in the earth as in the case of a walls or buildings, or attached to what is so embedded for the permanent beneficial enjoyment of that to which it is attached. But I must sensitize the thought process, because I believe a age old principle, I think and therefore I am. If you compare two definitions in section 3 of the Transfer of Property Act, immovable property does not include standing timber, growing crops, or grass. This is the exclusionary definition. If you compare it with the attached to earth, there is a conflict. I have a suggestion that as a law student, we should always, and when I say student, I mean me also, because every lawyer or any lawyer for that will always say, I am practicing law since last maybe 5 years, 10 years, 20 years, 40 years. But that word practice and ing never goes. The conflict between two words, immovable property, does not include standing timber, growing crops, or grass, compared with attached to earth, is rooted in the earth, is in conflict as it refers to the trees and shrubs. So these are the conflicts in the primary definition of the property. So traditional concept of the property will always have following features. One, control over the use of the property, right to take benefit from the property, right to transfer or sell the property, right to exclude others from the property. These are the facets or features of the ownership. And at this juncture, I believe, if you want to understand it more efficiently, the provisions of the Sale of Goods Act, because I said control over use of the property, and right to take benefit from the property, and right to transfer or sell the property. If you look at the concept of section 42 of the Sale of Goods Act, please listen to me little carefully, be with me. The buyer is deemed to have accepted the goods. See friends, we are dealing with the movable property now. So it says the buyer is deemed to have accepted the goods when he intimates to the seller that he has accepted them. It is very simple. If I intimate to you that I have accepted, the property and the goods are transferred. Or when the goods have been delivered to him and he does any act in relation to them which is inconsistent with the ownership of the seller. Take a pause. So if I'm the owner of this pencil, I have a right to use it. I can write the poem, I can write the plaint, I can write anything. This is exercising my ownership right. So ownership presupposes exercise of something in the property. I treat that to be my property. So whenever any buyer purchases the property and does something which is contrary to the ownership right of the seller, naturally it confirms the transfer of property in the goods being complete. Why I'm giving an example of the Sale of Goods Act? Because it very specifically deals with, of course, at the same time, I also must draw your attention to section 8 of the Transfer of Property Act. Section 8 of the Transfer of Property Act very clearly and very specifically, interestingly, stipulates and rules. Yes, unless a different intention is expressed or necessarily implied. This is a very important and interesting part. I may be permitted to give the example with a prayer and confidence in all of you that you will maintain professional confidentiality as a lawman. There is a property in Vadodara wherein a bungalow has been sold with a restriction that though I have transferred the property, you will not make any change in the designs of these windows. Naturally, you will be shocked to know that how can this happen? Yes, it has happened, and it has happened right in the Alkapuri society. There is a sale deed in respect of one of the premium building or a premier building in Alkapuri. Earlier there was a bank, and now there is some jeweler. But the sale deed does stipulate, I'm just trying to sensitize you, unless otherwise agreed or necessarily implied, the transfer of property passes forthwith to the transferee all the interest which the transferor is then capable of passing in the property and the legal incident thereof. I'm not reading the whole section. They are already available in the Transfer of Property Act since 1882. I'm trying to propound that whenever there is an instrument of transfer of property, the property passes there with all the interest. The word used is all the interest, and of course there is a list enumerated that these are the incidents of transfer of property. Naturally the question may come in the mind of the person that means that unless there is no instrument, there is no transfer. Friends, please remember, it is a myth. There are two sections, namely section 5 in the Transfer of Property Act and another section is section 9 of the Transfer of Property Act. Both these sections are capable to confirm. See friends, please remember, there is a difference between transfer of property as defined in section 5 and the transfer of property depending upon the nature of the property. Meaning thereby, I have a revolver lawfully purchased. No, actually, I don't have. I don't need it. My pen and my tongue is more powerful than the revolver. But suppose, example, I have a revolver in my hand, duly lawfully purchased with the prior license given to me by government of Gujarat. And then I decided that I want to sell this revolver and want to purchase little better and the latest model of the revolver. If you or one of you are holding the license of the revolver, I can sell you my property. Naturally, when I read section 5, don't ask me question that sir, oral transfer is permitted, because section 5 says transfer of property defined. And if we read the section in conjunction with section 9, section 9 says a transfer of property may be made without writing in every case in which a writing is not expressly required by law. So this is an exception to the rule. The rule is transfer of property can be done without writing except where it is specifically required. I must tell you that the exception is immovable property emerging from Registration Act, which says that whenever the immovable property is having value of more than rupees 100, which I find very funny, because when I studied the law and even as on today I'm using the law, the value of the rupee has still remain rupees 100. I am not at reasonable logical platform to understand that why rupees 100. These are some of the provisions which are colonial, and probably when the law was drafted they were not aware that our nation, that is we the people of Bharat and not India, can become the third big or second big economy, to which we are heading very very sincerely. But then this is what it is. The Registration Act makes a compulsory mandatory requirement to have the instrument whenever the transfer of property is a immovable nature having a value of more than rupees 100. A very pathetic poor kind of a provision. 100 rupees have no value, but anyhow the purpose is when the value of the property is more than rupees 100, and if it is a immovable property, it is compulsory required to be registered. Coming back to the effect and the definition of section 5, be with me in the following sections. So this, look, section 5 is the initial level of the Transfer of Property Act. It runs into long number of sections, almost running into more than 137. If you look at it, it says in the following sections, transfer of property means an act by which a living person conveys, hand over, api devi, give away the property in the present or in future. So you please understand, in the present or in future means you may not have the property today, but you can give that property today, though you may not hold the property. Look at the flexibility of law. To one or more other living persons, or to himself, or to one or more other living persons. And the transfer of property means to perform such act. A nano. I'm not trying to teach you the language, but English is a poor language. If you write small a, it is an action to act. If you write a big A, it is an enactment. That is the poverty of language. No problem. So foreign language, I respect it, but this is how the difference is. Section 5 in 2 lines says, whenever there is an action to convey the property, it amounts to transfer of property. Meaning thereby, section 5 and section 9, I can make the oral transfer unless it is not made compulsory for registration and writing. Otherwise, with all respect to reality, if you compare either ABB, Schaeffler, GSFC, or big organization, if they transfer the property, maybe worth around 50 crore rupees, maybe a small, maybe a boiler or a big, transformer, or a big article, maybe worth around 2, 3, 4, 30, 20 crore rupees. The property can be transferred through invoice and a lorry receipt. At this juncture, it would be interesting to refer the provisions of section 2 subsection 4 in the Sale of Goods Act. By the way, friends, before we enter into the intra-internal use of the Sale of Goods Act and the Transfer of Property Act, I must draw your attention of section 3 to Sale of Goods Act. It says the unrepealed provisions of the Contract Act. The word Indian is written, but I'll request you, as my dear friends, After this session, never use the word Indian in your using the language or the name of the law, because the word Indian Contract Act, the Indian Succession Act are all being gift of those white people who came here to do the black business for 250 years. They spoiled our language. They may be Gujarati, they spoiled our life, they spoiled our culture. So don't use as a small gift, please don't use the word Indian Contract Act, because the word Indian wanted or desired by them, because when the law or the cases in India was going to the Privy Council in England, the English judges were required to know that this case has come from India. That is why they added the word Indian. Now it is our self-esteem. જે લોકોએ આપણા દાદાજી બાપાને ગોળીઓ મારી, ફાંસીએ લટકાવ્યા, જલિયાનવાલા બાગ to Savarkar and Bhagat Singh to Mahatma Gandhi, everybody suffered. At least now we should not use the word Indian. Coming back to the law from the life, the section 3 says the unrepealed provisions of the Contract Act, save insofar as they are inconsistent with the express provisions of this act, shall continue to apply to contracts for the sale of goods act. This section very clearly communicates that Contract Act and Sale of Goods Act both move together in a similar fashion. If you look at Section 4 of the Transfer of Property Act, I call these a section to be the bridging provisions. The chapters and sections, I'm reading Section 4 of the TP Act, the chapters and sections of this Act which relate to contracts shall be taken as a part of the Contract Act. So if you look at, there is a triangular bridge between three. The Contract Act is the top of the angle in triangle, and two small angles in the triangle are either the Transfer of Property Act or the Sale of Goods Act. They all bridge each other with this kind of a intra-internal relationship, bridging relationship established by the provision of law. I was on the point as to what is the ownership and the title documents of ownership. In case of a bungalow in Alkapuri or a plot in Baili, you are all aware that it would be regulated by the Transfer of Property Act. Section 54 of the Transfer of Property Act provides how the sale is being done. But if you look at the concept of the transfer of property in case of the movable property, and when I say movable, it is essentially tangible and the physical recognized by the Sale of Goods Act. It says document of title to goods includes a bill of lading, dock warrant, warehouse keeper certificate, wharfinger certificate, railway receipt, multimodal transport document, warrant or order for the delivery of goods, and any other document used in the ordinary course of business in proof of the possession or control of goods. You people must be regularly using wonderful services of Amazon. I believe yes. When the Amazon packet is received by you, then he delivers and asks you to give the password or the passcode which is being received by you, and then he delivers that electronic document of a passcode is the document of the title of the goods as defined in section 2 subsection 4 of the Sale of Goods Act. I'm just trying to sensitize that Amazon is also a seller of goods and you are a purchaser of the goods being fully regulated by the Sale of Goods Act. So I'm just trying to sensitize that the transfer of property as envisaged by law can be oral by an action to transfer the property, and if it is manifested in some document recognized in the due course of business, then it is capable to convey the transfer of property. Please remember therefore that a very traditional orthodox way of transfer of property is neither envisaged nor expected by the law. Of course, I draw an exception that when the immovable properties are there, then depending upon the nature of transaction, the nature of document and the procedural formalities would be required. This leads us now to any query till this time on the point. If no, I'll move ahead. Hello. Hello. Okay.
Yes, yes,
Anyhow,
yes, sir. Please
yes,
go
yes,
ahead, sir.
yes, yes. Thank you. So now dealing with some more laws. There are some other statutes which are also equally concerned with the transfer of property by operation of statute. Till this moment, we were talking of the transfer of property by act of the person. Now, I am also required to refer because the topic of the today's session is procedure and principles for transfer of various property through various ways. There are statutes known as Succession Act. Again, I am dropping the word Indian with all conscious commitment for the honor of our nation. The Succession Act, the Hindu Succession Act, and the Partition Act. These are and can be the examples to show that the property can be transferred by operation of law. I repeat, an operation of law. I am born in a family, or I am in the most powerful and the great place of the world. There is no other place more powerful, more protected, more safe, and that is the womb of my revered mother. If I am in the womb of my mother, Hindu Succession Act says after the child is there in the womb beyond 3 months of pregnancy, and if my grandfather dies, I am entitled to receive the share in the properties of my grandfather. मेरे पास और कोई लायकात नहीं, except my life has come into that wonderful body gifted to me by my mother and father, and I am in the womb of my mother. I get the property. I'm just trying to sensitize the transfer of property by operation of law. Hindu Succession Act defines section 8, Hindu male dying intestate. कोई हिंदू पुरुष विल किए बिना गुजर गया, then his Hindu joint family property, Hindu undivided family property becomes the property of the persons who are defined as the legal heirs in the schedule of the Succession Act. I become the owner. The transfer of property occurs without any intervention, forget about involvement of any overt, open, or physical act of the person. It happens by operation of law. My father owned the property. He's a Hindu male. Section 8 says when Hindu male dies without making any testament, I become the owner of the property. Suppose if my father has left the earthly world on 9th of June 2006, the moment he left the world, I become the owner, and my ownership is established by virtue of three facts. One, my father having acquired the ownership, my father having left the earthly world, and I am born to him before his death. Or as I told you, 3 months in a pregnancy, I become the owner. I become owner of the property. So this is one more shade which you all must know well, that the property and its transfer also occurs by operation of law, not necessarily and only by the act of the person. Of course, that is what it is prescribed in Section 5 of the Transfer of Property Act. This leads us now to the discussion also on one of the important element or the features. Sir, just let me know, the time also I have to adhere to maintain, because if I am exceeding my time, please let me know. I believe it is 5 to 12, huh? 10 minutes more.
Yes, sir. Yes, sir.
Okay.
12, 10, fine, sir.
Okay, 5, 10 minutes is fine.
Yes, sir. Yes,
Okay.
sir.
Okay. Now see, this requires us to look at the important elements of some of the major area of transfers of property as it occurs either in Sale of Goods Act or the Transfer of Property Act. And as I have already shown to you, the Transfer of Property Act and Contract Act, the Sale of Goods Act and the Contract Act, they are two sides of the same coin. I must bring a very sensitive attention to the discussion in this forum, and that sensitive, serious point in discussion should be oriented with Section 1 of the Contract Act, friends. Why? Section 1 of the Contract Act says that whenever there is a contractual relationship, friends, it would not only be regulated by the terms of the contract. You may go to the brilliant lawyers, you may go to the big lawyer firms, and they may charge you hefty fees. Yes, that's their privilege, their choice. And you get a wonderful document capable to give you a very effective kind of a mechanism to carry through your Transfer of Property Act transaction. But Section 1 of the Contract Act very clearly and very specifically rules and states that that whenever there is a contract, the incidents of contract also decide and govern the rights of the parties. Section 1 says, notwithstanding anything contained, nothing herein contained shall affect the provisions of any statute, So Contract Act will not affect any statute. Giving an example, sale of a revolvers, sale of a petroleum product, sale of any other thing, either tobacco now, school ni aju baju lakhe che logo, people write tobacco is not being sold. So because it is a revolver, because it is tobacco, because it is petrol being regulated by different act, Contract Act will be applicable together with the Arms Act for revolver, the the law relating to the sale of the Petroleum Act will be applicable. So Contract Act is applicable together with other acts which are not expressly repealed. And now be with me with all seriousness, nor any usage or custom of a trade or any incident of any contract. Please understand, this gives a very clear message that a great document, contractual paper, the formal contract being drafted. Friends, please remember, your conduct, behavior, and circumstances emerging from the contract also will create an effect, or it will affect the performance of the contract. So I always say that a wonderful vehicle, the good document being created, can suffer if you are not able to use it effectively. This leads us to the major five modes, I'm sorry, major five types of the transfer. One is sale of the property, sale of immovable property. When it is a immovable, it is sale as defined in section 54 of the Transfer of Property Act. Then when it comes to question of a sale, I must also draw your attention to some of the important provisions of the Sale of Goods Act, and it very clearly says the definitions as to how the contract for sale is made, then stipulation as to time, stipulation as to quality. But I must also specifically, because it is short time, but because the subject deals the procedure and the principles for transfer of property, section 19 of the Sale of Goods Act requires a very serious attention. Where there is a contract for sale of the specific ascertained goods, the property in them is transferred to the buyer at such time as the parties to the contract intended to be transferred. So your intention should be expressed through some term, through some condition, through some conduct. So meaning thereby the property in goods. I will explain this jurisprudential statement. What is the goods and what is property in goods? I'll make it very simple. You are holding a pen in your hand, a very nice pen gifted to you by your mother or father or some dear friend, and you are in a bank. I know nowadays this situation may not be there because everybody is on the online banking, but visualize the situation. You are in a college, you are in a bank, holding a pen and filling up the form. I am standing beside you. I am not a responsible student, not carrying a pen in my pocket. I ask you that, Mr. Gupta, Madam Iranji, please give me your pen. You give me pen for signing my form for 3 minutes. The property in goods remains with you, the good remains with me. If I put it in Hindi, जो वस्तु है वो मेरे पास है, उसकी जो प्रॉपर्टी है वो आपके पास है. So property is equal to ownership, and ownership is invisible, the property is visible. अभी मैं आपके साथ बात कर रहा हूं, मैं जहां मेरा निवास स्थान है उसको ताला लगा के मेरे कार्यालय में आया हूं. The key is with me. So ownership is with me. The possession of my property, वो मेरे घर में कोई चूहा होगा, कोई मकोड़ा होगा, they are holding. I'm not cutting a joke, but I must tell you, the physical element of the property is transferred when the parties intend to transfer, is one of the most important provision in the Transfer of Property Act. I'm sorry, in the Sale of Goods Act, to which I must draw your attention. Then this requires us to go to after sale. Then I refer to the lease. I must also bring it to your notice that the concept of a lease and mortgage, there are two types of the property where partial transfer occurs. When you mortgage the property with the bank, you hand over the original title deeds and you continue to pay the installment. So because the title deeds are transferred, the definition of a mortgage, I am not good in mathematics, but somewhere in section 57 or 58, 59 of the Transfer of Property Act, friends, mortgage is a transfer of ownership to secure the liability created in that property. So you give the original title deeds to SBI or Bank of Baroda, they give you the loan till you continue to pay the loan installment. The property's title is remained transferred for securing the loan repayment. If you don't pay, you know well, Adaraniya Vijay Malia, or with respect, Nirav Modi, though have ran away, their properties are being sold by SBI in Bharat. So ownership when transferred, it is mortgage. When possession is transferred, it is lease. So you purchase the flat or you purchase the office, you give somebody the lease, the person has a possession, ownership is with you. In case of a mortgage, you have a possession, the ownership is transferred by you in favor of the banker or otherwise the creditor. So that is a partial transfer of property are the examples. Of course, at this juncture, I am tempted to also give one extended reference: lease and license. They are like ma and masi. Lease is a mother. Why? Because lease is a transfer with larger interest in the property. If you have transferred the property by lease in my favor, and because I'm a very devout Vaishnav or devout follower of some religion, do I come and ask you that I want to do a Satyanarayan Puja? Please give me permission. Do I need to ask? No. विथ ऑल रिस्पेक्ट टू रियलिटी, मेरे में संस्कार नहीं है, तो शाम को सत्यनारायण की पूजा करने के बदले गुजरात में प्रोहिबिटेड होने के बावजूद यदि मैं दारू पीना चाहता हूं, बिलीव मी आई डोंट डू दैट. डू आई नीड टू कम एंड आस्क यू परमिशन कि सर आज ड्राइंग रूम में बैठ के आई वांट टू ड्रिंक अ लिकर? But if you have the property on license, the best example is paying guest facilities, the best example is hotel. I have hired a hotel room in Ahmedabad because I am working as a vice president law in some company, and the company has given me the room in a hotel, one of the finest hotel in Ahmedabad, and I want to hang the photograph of Lord Tirupati or Ranachhodji from Dakor or Dwarkadhish from Dwarka. Can I hang the photograph in hotel room? Answer is no. If I want to have a Satyanarayan Puja in hotel, though I have paid the room rent for 5 long months in advance, can I use the hotel room for doing these kind of activities? Answer is no. So I'm just trying to sensitize you. License is a concept under the Easement Act section 62. Lease is a concept under section 101, 106 of the Transfer of Property Act. The property remains same. The immovable property, when interest is transferred, it is lease. When interest is not transferred, it is license. Moving on to another important area of the transfer of property is exchange and gift. We are all aware that there is one specific, special, and a unique feature of a gift, which we are all aware that generally gift is out of love, out of commitment. And we are all aware that the life which is gifted to us by our parents, most invaluable, most precious, and uncomparable gift, that is the life. So when somebody has gifted to us, we should always feel obliged. Same principle is there in Transfer of Property Act. When somebody gifts the property out of love, out of devotion, out of care, there is no consideration. The feature which I'm trying to point out, that if the property is transferred without consideration, namely by way of a gift, in case of a will also, the transfer of property is taking place through testament. I made a will, and in my will I stated that my all properties be given to the Ministry of Defense for the wives of those soldiers who unfortunately left the earthly world in the war occurred in the year 1971 with wonderful useless enemy, namely Pakistan. I can do that. So the will and the gift, there are two documents which occur into transfer of property. In gift, it occurs now and here. In will, it occurs after the death of a person. But both transfer occur without consideration. So therefore, there is a provision that both the documents should be signed by the attesting witnesses. And when you want to prove the completed validity or legality of the transaction, either will or a gift, you need to examine those witnesses. I'm trying to sensitize because topic says the principles and the procedure for transfer of property. Be careful. I cannot have the time to enlarge, but whenever you want to do this kind of a document, be careful and conscious for the compliance. Last on the list is exchange, which is hardly being used. I have a big flat in Kolaba. Malabar Hill, and you have a big plot in Vadodara, we can exchange that. If the value is matching, then the exchange that can take place. Of course, that is not that highly used transaction for the transfer of property. Before I conclude, it would be unjust, it would be unjust or injustice not to deal with intellectual property rights law. And the example I must give it to you, that unlike immovable property, if I draw your attention to the transfer of property in the trademark, which is a similar provision is available, it is dealt with in chapter 5, assignment and transmission. So power of registered proprietor to assign and give receipts. So if you look at the broad principles of the assignment or the transfer of property of the trademark, you must know well that assignment is required to be mandatorily notified to the registry of trademark. So if you transfer it without assignment being complied with in accordance with the Trademarks Act, believe me, the rights of the ownership in the trademark may get adversely affected, meaning thereby if somebody is infringing your trademark, you may not be able to effectively enforce your rights of ownership. These are the examples to convince you that transfer of property act in case of an immovable property, if you don't register the document, it is a useless piece of paper. ગઈકાલના newspaper જેવું થઈ જાય. એવી રીતે trademark act also has a provision. It is an intellectual property right law which also prescribes that the assignment is required to be registered. Similar fashion provisions are there in case of a patent, in case of a design, and of course in copyright it is not that strict, but these are the effective provisions capable to confirm that you must be owner of the property, and when you want to transfer the property, you must go to the provisions of the respective substantial law. I repeat, a substantial law, and which will answer the procedural aspect for the transfer of property. Last but not the least, whenever there is a transfer of property, it is always better that you should check the veracity, title, competence, and transferability of the property, giving a reference to the principle of a law in Transfer of Property Act, Section 53, fraudulent transfer. Whenever any person is attempting to transfer the property to delay or defeat the claim of creditor or some restriction against the property. So whenever you want to purchase, acquire, own, take the property from somebody, be a bona fide purchaser, meaning thereby make an inquiry about the ownership of the person intending to transfer, make an inquiry about the transferability of the property. If I explain this last principle in one line in Gujarati proverb, દીકરીનું કુળ અને જમીનનું મૂળ જોયા સિવાય સંબંધ ન બાંધવો જોઈએ. I am not intending anybody to be insulted, but the relationship between the person and the property is designed to create a happiness. If you are not careful, either qua the titles or competence to transfer or the procedure to effectuate the transfer, believe me, the purpose of Transfer of Property Act may create the transfer of pain and not pleasure. I wish you all to have a pleasure not in the law but in life too. Namaste and dhanyavad.
Thank you very much, sir. Your thoughtful inputs on particular various forms of transfer property law. So, participant, you can put the question in the chat box or you can raise your hand. So there are questions like, sir, property owner one shop contract with a person rental shop as per Bombay Hotel and Lodging Act. After some time, the owner had died. Therefore, the contract is not continued with the new contract with legal heirs. One second, sir. There is a long question. Or the said
No,
contract void with died of the said owner. So
no,
what's your
I'll answer this question. If it is a
yes?
Bombay Hotel and Rent Lodging Houses Act, then it is a regulation which is available in addition to the Transfer of Property Act. The answer lies in two laws. One, the provisions concerning Section 108 of the Transfer of Property Act and Section 511C of the Bombay Hotel and Lodging Renting House Act, where the person, if he dies, if it is a residential house, his family member is the word used. And of course, you know well that the judgment law is always more flexible and adaptive. So who can be family member? There are varied judgments. But if the person is a tenant and if he has a family member living with him for 1 year prior to his death, he succeeds to the rights as a tenant. In case of a commercial property, he should be doing a business for 6 months prior to the death of that original tenant, then he becomes tenant. But conditions are two: he should be family member and he should be actually doing a business jointly with him. I hope I am able to answer the query. And there was another question, somebody had flashed it on the screen, that if the mortgage is required to be registered or not. See, friends, remember this question is being dealt with by the Registration Act. So far as the Gujarat is concerned, it is compulsory even to register the simple mortgage, or what you call the mortgage by deposit of title deeds. Earlier it was not required, now it is required, because ultimately people were trying to, play the fraud with the banks and creditors. That is why it is now required. And you must know well that now government of Gujarat has taken a very innovative step. Whenever you do any deed duly registered with the registrar, it will be immediately notified to the revenue records. In case of agricultural land, 712. In case of the city property, known as the city survey card. So therefore, to prevent this kind of a pilferage, now the provision is there that it is required to be registered.
Okay, sir. There are a couple of questions. Sir, can you please repeat the difference between lease and license?
Okay. The word lease is defined in the Transfer of Property Act. License is defined in Section 62 of the Easement Act. And the material difference, by giving little indecent example, by cultural commitment, I have got married. Yes, tell me. By cultural commitment, I have got married to a wonderful woman. So Dipali is my wife. The marriage is equal to lease, where the relationship gives emergence or results into the reciprocal liability, obligation, rights, and duties. And license is equal to live in relationship, which you all know well. Nowadays, so many people, they are living like an animal. There is no commitment, right? You are living in a hostel, it is a license. And the material difference in law, if I put it, in lease, there is a transfer of interest in the property. In license, there is no transfer of interest in the property. In a hotel room, if you hire maybe for 3 weeks or 3 months, there is no interest transferred in the property. You lock the premises, and after you lock the hotel room, you hand over the keys to a beautiful artificially smiling girl on the ground floor. That is why you have no control on the property. In case of a lease, you are not required to hand over the keys. You carry it in your pocket. That is why I gave the example. In case of a lease, I want to have a Satyanarayan Puja in the evening. I don't come and ask you that, can I do it? If you want to do it in hotel room, can you do it? Answer is no. So license is a temporal permission granted to use the property. Lease is a transfer of possession, because every property will have two elements: ownership and possession. Ownership is invisible, it is manifested in the physical form through possession. When you transfer the possession with interest in the property, it is lease. When you transfer the possession without interest, without control on the property, then it is a license. Both provisions and laws are different. Section 62 of the Easement Act is license. Section 101 of the Transfer of Property Act, lease. I hope I am able to answer your query.
Okay, sir. Next, Rajiv Sahni.
Yeah. Good afternoon, sir.
Namaste.
Sir, you just talked about transfer requires conveyance. Conveyance is a requirement for transfer. There is a
Hmm.
practice, it's a practical
Hmm.
aspect. There is a practice application that
Hmm.
under construction property, the
Hmm.
agreement to sale is registered and no other document, no other follow-up document subsequent. So
Hmm.
what is whether that completes the conveyance, and if not, what is the gap and how that can be filled?
Section 54, last provision, last part of Section 54 of the Transfer of Property Act defines what is contract for sale.
Right.
It includes the power to transfer the property at a future date, subject to certain terms and conditions. There are models in the real estate industry where agreement to sell is entered into with the development agreement in favor of the developer's firm. So technically, the transfer of property under this kind of agreement take place only when the agreement to sell and the performances thereunder are completed or fulfilled. However, because your question appears to be intended with what are the rights or interest of the person in whose favor such contract for sale or agreement to sell is being made. I must give you little out of the topic information or reference. Now, this Real Estate Regulation Act has come into force, which, though Transfer of Property Act does not recognize those rights, but the extended hand or arm of law, namely RERA, recognizes such agreements to sell as the agreements having created the interest in favor of the purchaser. And those rights under agreement to sell, though under parent law, traditional law of TP Act, they are not enforceable, but the extended hand of the TP Act RERA does recognize your right as a purchaser of the flat which is under development. I hope I am able to answer your query.
Thank you.
Another question: how to prove oral transfer under Section 9 of Evidence Act before the court?
Answer: oral transfer, Section 9 of the Transfer of Property Act recognizes that unless otherwise required, the oral transfer can take place. The answer to this question is lying or is rooted in the Evidence Act. This now amended as a Bharatiya Saksha Adhiniyam. So far as evidence, friend, is concerned, it includes the fact having come to your knowledge through your sensory organs. As I told you, Shabda, Sparsha, Rupa, Rasagandha. I am not talking of Shabda and Sparsha, but a Rupa. Rupa is not dancing girl on the floor. The thing which you can see through your eyes can be evidence. So you and me, we both are sitting in a coffee shop in Vadodara, a Koa coffee, and I tell you that ये देखो यार मेरे पास बहुत अच्छा पेन है, which is gifted to me by one of my very old friend. But you know, unfortunately, that old friend who gifted me this pen has left the earthly world. So whenever I see this pen, I'm not able to forget him. So I want to sell out this pen. You said, okay, sir. What do you think the price? I said 15,000 क्योंकि वो Schaeffler का पेन है. बोले ठीक है sir, I'll do one thing, I'll give you 5,000 rupees. You give me 5,000 rupees in a coffee shop, I hand over you the custody of the pen, and then you don't pay me 10,000 rupees. Me and the coffee shop attendant or the helper can be witness कि हाँ sir, ये दोनों के बीच ये पेन के बारे में बात हो रही थी. So his oral evidence, my oral evidence can prove the existence. So when I say it is a oral transfer, the oral evidence is accepted, because the concept of evidence is misunderstood by many. The word evidence, the moment I say, you will always expect a document. No, the evidence can be oral too. Right now I am sitting in my office. If I hear the shot of a bullet and the murder trial takes place, police can examine me as a witness that as 12 past 15, there was a bullet shot which was heard by Mr. Sumant. So I can be the witness of the facts occurring. My knowledge should be there. So oral transfer can be evidenced by oral evidence.
Last question, like by Natraj. Natraj, over to you.
Yes, sir. Thank you, sir. Sir, here husband purchased the property in the name of his wife, and after the death of wife, he wrote a registered will. Okay, for the entire property. So, what is the validity of the will, sir? Husband can do that while the property is in the name of wife.
See, answer to your question also requires a reference to Benami Transaction Prohibition Act, because the Benami Transaction Section 2 subsection C also defines the property. But it also very specifically provides that if the husband purchases the property, if it is proved from the sale deed that the money is being paid by husband in the name or on behalf of the wife, then the real owner is husband and the wife is ostensible owner, if it is proved that she has not contributed any amount as a purchase price to acquire the property. But advisably in this kind of situation, if the husband has made a will, then the will should be properly structured by writing that this property was purchased in the name of me and my wife jointly out of my love and commitment in the relationship. I remain the real owner. My wife was an ostensible owner. If that kind of a will is there, it is advisable that it may have the good effect. Otherwise, subject to the factual matrix, who has purchased the property is the answer, which lies in who has paid the money. giving a cross reference, there is a provision in Transfer of Property Act that ownership of the property is in equivalence to the value of money you have paid for, otherwise unless agreed. So if me and you, Mr. Natarajan, we have purchased the property, I invested 20 paisa, you invested 80 paisa. If the sale deed provides that notwithstanding 80-20 division in the sale price, we both remain 50% owner, then the ownership will attributed to the primary financial, monetary, fiscal consideration being paid. So in this case, whether wife has contributed or not, if not, then what is the position in the sale deed and the will, that will answer your query. I hope I am able to guide you properly. May not be able to answer your query because it is a factual matrix.
So we can take up last question like what is a Benami transaction? Like in brief, you can explain. This will be last
See,
question, sir.
Benami Transaction Prohibition Act of 1988 is now amended recently, not very recently, but now the Benami transaction is being amended. The word Benami is basically a concept which is communicating or conveying a message that the person who has acquired the ownership by making a payment is the person in whose name the property does not stand. So property is in the name of one person, whereas the consideration to acquire the ownership is paid by another person is the Benami transaction. And Benami transaction is the law which is founded on the principles in equity, that is morality in law, that if the property is in the name of Dr. Kalpesh Gupta, I have paid the money, then I will be at the mercy of Mr. Gupta. If he sells the property, the law will not protect me on the ground that I have paid for the consideration. So it is basically a law based on the morality that who pays the money is the owner and not the person at whose behest or at whose instance it has been paid.
Okay, sure, sir. So like one last, I would say when witness are dead, so how to prove the like will that case,
There is a
both the
provision
witness.
in Succession Act. There is a provision in Succession Act. If my memory serves me right, it is a section 68 of the Evidence Act. I am little bad in the mathematics, numbers में थोड़ा weak हूँ. Not the math, वो मेरे जिंदगी के गणित में नहीं, मगर लॉ के सेक्शन में मुझे याद नहीं रहता. तो सेक्शन 68 में प्रोविजन है. If the witness is alive, that is the word used, then that witness should be examined. If that witness is not alive, then his son can be called that this is a signature of my father. Corroborative circumstantial evidence can be brought in to prove the signature of the witness. It is not a helpless situation. The seeds of the absence or the death of the witness are sown very much in the section itself of the Evidence Act. Of
Sure,
course,
sir. Sure.
not going little far, but if in case of a will, if you want to make the will, then instead of two witnesses, I will advise keep four, because law prescribes minimum and not maximum. And you try to keep all those four witnesses. This is not written in law who should be 50% of the age of the testator. So today I am 56. If I want to make a will, I will keep the witness who is between 25 or 20, because mother nature says that the person who has come first will go first. So if I leave earlier, my witness should be there. Not, it's not there in law. And advisably, you should have the witness who is generally possible to be available in Bharat. और फिर अमेरिका कनाडा चले जाने वाले लोग होते हैं. I respect them, but then kindly take care. See, it is all subjective. There are many, because in the will there are many modes to ensure the authenticity. Instead of making a will in a typewritten form, tell the testator to write the will in his own handwriting. It is known as a holograph will. So therefore it becomes very strong will. You get it drafted from the lawyer, lawyer's paradise. वकीलों को भी पैसा फी चाहिए तो उनको पैसा देके make a draft, but write it in your own handwriting. It will add energy to the existence and enforceability both. Repeat, existence and enforceability of both in the will. I hope I am able to answer the query.
Sure, sir. So thank you very much. I think sir, we have taken most of the questions. So again, as usual, sir, you are like let me tell you, all the participants sir has been part of various program, earlier program, right? Like people, participant, they keep asking, sir, where is the PPT, PowerPoint presentation? But sir is the only speaker, I would say, in our all the program without anything, the brief notes with pencil in hand. So sir, discuss so many things in sort of span of time with detailing. You can say you might have seen last 1 hour, and then this will be like ideal for all of us how to prepare for particular concisely prepare and put it before the audience. So thank you very much, sir. On behalf of organizing committee, we are grateful for your
So
wonderful time.
somebody asked my mobile number. I can share my personal email ID and mobile both with a request that I believe law and medicine, these are the two areas of science, social science. I'll add one more: law, medicine, and education. It should be freely accessible, and that is not in conformity with the Western way of looking at it. But you can jot down, it is Vidhi underscore Avadhoot at yahoo.com. I spell VIDHI, Vidhi underscore Avadhoot, A for action, V for victory, A for action, D for Dandavat, H for Hindu, O for outstanding, again O for outstanding, and T for Trambak, Avadhoot at yahoo.com. And my mobile number is 98240 But I prefer to use the text messages instead of WhatsApp, not going to length, but jitna kam ho utna acha. Whatever less is always better. तो व्हाट्सएप के लिए स्मार्टफोन चाहिए, इंटरनेट चाहिए, मोबाइल टावर चाहिए। एसएमएस में छोटा सा मोबाइल चल जाता है। तो आई बिलीव इन लिविंग विथ लिस्ट पॉसिबल रिक्वायरमेंट्स। तो टेक्स्ट मैसेज करिए एंड जनरली आई रिस्पॉन्ड। बाकी आई विश इन द लॉन्गर पाथ ऑफ लॉ एंड लाइफ we remain and meet together again. Thank you very much.
Sure, sure. Thank you very much.
Friends, should I leave the meeting now?
Yes, yes. Thank you, sir.
Thank you.